Yes. You wanted to say something, Mr.
One thing, my lord. I had promised your lordships Saturday hearing there would be coffee and muffins. I've arranged for that. It's outside, my lord. Different kinds of muffins, savory and sweet, and warm coffee.
My share, you can give it to my law clerks because
Yes.
I don't eat sweets.
Well,
So they would be entitled to my share of it, so you can give it to them.
It looks like your lordship doesn't eat sweet. It's savory croissants are also.
Oh,
Yes.
there's a savory muffin also. I don't think.
But-
We'll be in the newspaper tomorrow if he starts snacking in court.
Are not in bar and bench and lifelong money.
There's no press person available here, I'm sure. Oh.
Don't be so sure of that.
We may never know.
Possibly they could be online without why Saturday the court is open.
And how is poor Mr. Nakul Diwan going to get his share there?
Online.
Mr. Diwan has assured us of a trip to the UK, my lord.
I
So
see.
you can have breakfast there.
Very good.
Well, as of all
Yes.
the
And on the last occasion, senior most counsel appearing for the appellant will begin. In terms of seniority, you continue. No repetitions. Try to complete as fast as possible. And let's hope that it gets over. We'll sit till 1:30.
But there's only one submission.
Because I understand the registry has a half day on Saturday, so I don't want to cheat them of
very,
the half day.
very grateful you also found the time.
There's only one submission, and most of the matters may not I am appearing for the respondents. I would not urge your lordships to consider this aspect. All the petitioners can argue, when I reply them, I'll put in my SLP as well. My civil.
At that point of time, you can argue your
Great.
There's just one thing.
Milord's,
Dr. Singhvi
sorry,
starts.
Milord's, I am appearing for the resolution professional.
not here, Mr. Nakul.
That's right, but Milord's, I don't have much of a role to play today because I think, Milord's, it's for your lordships to hear both the sides. And Milord's, if your lordships requires any assistance, Milord's, I am available to provide that
Right.
assistance.
Very good. Yes. You wanted to say something, Mr.
One thing, my lord. I had promised your lordships Saturday hearing there would be coffee and muffins. I've arranged for that. It's outside, my lord. Different kinds of muffins, savory and sweet, and warm coffee.
My share, you can give it to my law clerks because
Yes.
I don't eat sweets.
Well,
So they would be entitled to my share of it, so you can give it to them.
It looks like your lordship doesn't eat sweet. It's savory croissants are also.
Oh, there's
Yes.
a savory muffin also. I don't think.
But-
We'll be in the newspaper tomorrow if he starts snacking in court.
Are not in bar and bench and lifelong money.
There's no press person available here, I'm sure. Oh.
Don't be so sure of that.
We may never know.
Possibly they could be online without why Saturday the court is
Of
open.
all
And how is poor Mr. Nakul Diwan going to get his share there?
Online.
Mr. Diwan has assured us of a trip to the UK, my lord. So
I
you
see.
can have breakfast there.
Very good.
well as of all
Yes.
the binding precedent of the Supreme Court, this particular precedent should be well as recorded in the future because this is a very happy precedent. Now, Willis, what I do propose to do
Yes.
is the seat broadly, Willis. First, tell your lordship who is who. Second, give your lordships an oral summary
Yes.
of the concept A and the heads of my argument B. All this will take about 10, 12 minutes, 15 minutes. I will then take your lordship through a list of dates, which will take the maximum time because I'll show the documents as I go along. That will make your lordship fully aware of the factual. And then I will, at the end, the fourth last head will be the legal submissions arising from the list. That's the sequence I intend to follow.
Very.
Now, as who is I am the appellant appearing in CA 1526 of 23 for the appellant petitioner.
Yes.
The name is Alpha Corp. I am the SRA. So the identity is important, not the name. I am the successful resolution applicant.
But we have three separate SRAs, if I remember.
Yes, correct,
separate.
correct.
Yes.
Then, Mellis, the respondent now is the principal opposition, which is my learned friend, Greater Noida. Respondent 2 is the corporate debtor acting now through the RP. Its name is Earth Infrastructure, EIN. That is respondent 2. I believe that is Mr. Nakul Diwan. Yes. And number 3 is Mr. Sanjay Bhalla, an individual who is an authorized representative of the real estate allottees of EIL. as far as I am instructed, I may be wrong, that 2 and 3 broadly support my case.
That's right. I appear for the monitoring committee.
This Sanjay Balla is the representative of the home buyers.
Home buyer.
Where the committee appointed, but not.
He is the
There's a
overwhelming
committee of-
supporter. He is the overwhelming representative, the largest number. However, Lordship should know that Mr. Anupam Lal
Was
appears for
appointed-
it. I'm saying so.
was appointed by the RP. We have a huge problem with him.
Very well.
A jailed
Right.
person.
So he is appearing for all of 13 persons, the princely figure of 13 persons, who are supposedly dissenting.
I've given a list of 800.
Cannot be because.
There can't be between 13 and 800.
There are
Mr. Guru
1800
Pawar will be swallowed up by 800 brothers. I don't know whom he is representing. He can't be representing ghosts for us. He can't be representing ghosts.
Very well, we'll come to that.
Now, brothers, the concept is this. Just very, very briefly, brothers, the heads of the concept. There are two wholly owned subsidiaries of the CD called NEU and NISHTA, NEU and NISHTA, N and N. Both are N's. They have a lease of land from Noida, but they happen to be the wholly owned subsidiary of the CD. But the underlying land is obviously leased to various SPVs. It is common practice that the land is given to broadly shell companies who only own the land. It happens in all the projects. It means nothing because somebody creates a company, it holds the land. And Noida gives the lease. That's all that happened here. So N and N are shell companies. Their only asset, their only reason for existence is the holding of this lease lands. They have no other business. The dispute in a concept sense is there a plan approved by NCLT? I'm, by the way, arguing a matter of reversal. I succeed in the NCLT fully. I'm reversed by the NCLT against me. The plan approved by the NCLT deals with this land and says that the whole concept of a home buyer's project is that I will construct and give the 1369 odd allottees or whatever the number now is. Obviously, there's no project of home buyer. In fact, no case of home buyer under Section 5 brought in by an amendment can exist without the underlying land. I cannot complete any project by the flats hanging in the air. So all projects will have, the land, it just happens that the land is by a wholly owned subsidiary of the city. The short issue arising is the very, very wide legal repercussions of the NCLT impugned order, which suggests that the land, because it is owned by NEU and NISHTA, and they are not in CRP, therefore land cannot be part of a CRP approval SRA plan. That's the short legal issue.
Yes.
The CIRP is CD, EIL. The land is with NNN. The person in the CIRP is EIL. You, Mr. NNN, can't be part of it. If you can't be part of it, land is also out of it.
Yeah.
That's the short thing. That's coming later. It sets aside the plan. Then a very curious thing happens. The impugned order adds a suffix. And there's a contradiction. Para 70 something and 91 something. I'll show those paragraphs. That while on the one hand it sets aside, it gives a remedy way out saying you can find a workout with the Noida and pay their dues. Their dues at that time were about 40 crores.
This direction is to the SRAs.
In the judgment. It's to all the home buyers, but
Liberty-
SRA will have to work it out with the home buyers.
Liberty is given to the SRAs to
Correct.
work out with.
Now, there is a contradiction. If you can work out by payment of 40 crores, there's no question of cancelling the project with the plan. Now, both exist in the impugned order.
While
Now-
setting aside the resolution
Yes,
plan,
there's a clear contradiction.
this liberty is given.
No, but that verse is to follow. The plan itself provides for the payment of 40 crores. So if the plan is implemented, you'll get 40 crores. The 40 crores is distributed over the home buyers in a methodical manner in the plan written down. Your Lordship is not concerned with the merits of the plan. That's the commercial wisdom of the COC. The home buyers are here largely, they are not objecting to it. He's not saying that, look, pro rata, I will pay, I am objecting. After this direction, Noida, just note one more thing with this, Noida watches from the side for the entire proceeding from NCLT, which is many years, from the date of the CIRP till the NCLT judgment in my favor, 2.5 or under 3 years. It watches from the wings. This is going to be an important factor for Lordship's overall consideration under the Supreme Court jurisdiction, originally starting from 136, now it's a civil appeal, which Lordship's equitable concern. Having got the judgment in NCLT, it leapfrogs and parachutes into NCLT for the first time and gets this order of reversal. That itself, now in this, the court having given a clear option to work out and the plan providing for it, which means it's already worked out. Noida gets up and says, no, I'm not here to accept 40 crores. Now, it has not intervened with the RP in the NCLT plan, saying that 40 crores is 42 crores or 39 crores. It doesn't, your Lordship, no, I have to file a claim there. He will evaluate everything. He doesn't do that. When the judgment comes and says, no, I want Shylock's pound of flesh. I want to decide whether this land can at all go into the CRP. It's my land, I'm the lessor. So that's as far as Noida is concerned. Lordship has the picture completely of where we stand. Now, the larger issue.
Only Noida says that. GNIDA doesn't say that.
No, it is.
Noida is
Are they two separate
No,
entities?
they are two separate entities, but this case
This
is
is
concerned
only
only
GNI.
Greater Noida.
Only
They
Greater
have
Noida.
used this word.
So Noida is not.
I use the word
Noida is not-
Noida, only for, it's only GNID.
Very
Doesn't matter.
Yes.
We say it's 30 crores, 40 crores, doesn't matter. It's all in the plan. Now, the other aspect is the larger issue which I am coming to. So, this is the lie of the land as far as the case is concerned. Now, the heads of my submission will be the following. One is the general larger issue that if your Lordship were to hold that the land which is in any project, the only asset is actually the land, the next is only building to construct. The construction part is easy relatively because you have brick and mortar and you have people and you charge. The land availability. So it would mean, so this is the larger issue which that in a sense, this could nullify by a side wind the entire object and rationale of the section itself. But the Lordship will rewind back to a lot of debate as to whether home buyers should have been included in IBC. They were not there for quite a long time. In fact, personally, I believe it's drawn a bit of a wedge in the whole concept of IBC. It doesn't. I argued the pioneer matter where we challenged the inclusion in 5A. Justice Nariman's bench upheld it. We said it's a square peg in a round hole or a round peg in a square hole. It doesn't fit in. But anyway, it was said that it's for the benefit. And even the government realizes, the report realizes that it doesn't really fit in because home buyers were not contemplated in IBC when it was originally enacted. It was for the NPA issue.
Yes.
This was a beneficial addition to help home buyers. So coming from that angle, if you start excluding from CIRP the land, then the majority of home buyer projects in IBC will be with great peril and jeopardy. That's the larger issue. The other legal issues are, one, I'm giving the heads only, then I'll come to others one by one. This is not a case of transfer of land at all. There's a direct finding in NCLT, which is on the face of it, is wrong. It's a 2 + 2 is 5 error. That I am holding this land to be outside CRP because it involves a transfer of land to away from New and Nishta. Now just test that for a minute. There's no transfer. Suppose there was no CRP. And this fellow, this EIL was constructing the project. EIL would construct the project with its own subsidiary having the land. Now the EIL is gone and what is the name? Alpha, SRA has come into what? He's stepping into the shoes of the CD. He will only do what the CD was to do. That's the concept of a knight in shining armor, in terms of the IBC. Now he doesn't transfer the land. He steps into the shoes of the CD, which is here. The CD has 2 subsidiaries here. They own the land. The CD is gone bankrupt, etc. This man comes in and completes the project. One of the other fallacies of the impugned order is that it says, look, the transfer of land involved. How can you transfer from a person who is in the CRP to a person outside the CRP? Therefore, we strike it. This is a fundamental error. It's a conceptual error which is both factual and legal. So, stepping into the shoes is forgotten, ignored, and mixed up. Incidentally, stepping into the shoes to complete the construction, I will show from at least 6 clauses or 5 clauses, is all that is provided already. I'll show the clauses in a minute, minus 2.2, 2.34, etc., etc. These are clauses from the plan which is approved up to the NCLT without Mr. Noida objecting and later parachuting into NCLT. The second head of my submissions will be that reference to section 7 is the same point actually of the UP Industrial Act, Industrial Development Act, which partly governs GNIDA, GNIDA. In a section 7, it says in the normal course you can't transfer land without prior permission. Well, obviously, if Mr. Ravindra Kumar gives me lease, I can't transfer to third person without the permission. That's all section 7 says. It's normal because any lease giving agency will have that permission. Lordship, DDA does the same. Indore Development Authority does the same. All of them do the same. So that is cited. That is the same answer. There is no transfer of land. What prior permission? You gave it to. Why did you give it to New and Nishta for development of a project? A SRS comes from the top. He's only developing the project. No transfer. That's section 7 point. The third issue, Malaz, is the larger issue, which is the legal issue, which is why Lordship has kindly put it on a Saturday. The interpretation of section 18 of the IBC Act to exclude assets of a wholly owned subsidiary will defeat the very purpose. This is a real issue, I would say, Malaz, of interpretation. And this will take your Lordships through 5.8 and 5.8F in particular onwards. It will take your Lordships to some law on deeming fiction. Your Lordship will note that there is an explanation I attached which says shall be deemed to be. Your Lordship knows when this homebuyer was brought in, shall be deemed to be was attached. And your Lordship judgments are clear. A deeming fiction must be taken to its logical conclusion. Here, Malak, there is no question of logical conclusion. The whole object of the deeming fiction will be defeated. You don't have to take it much. It has to be there, Malak. And the fifth head I will show from some debates, and they are fairly broadly quoted by Justice Nariman in the Pioneer, that the real object is a beneficial healing touch. So that's going to be a fifth head. From Pioneer, I'll quote that. Most of it is there. Insolvency Committee report, para 16 and all the other things. The sixth is some of the weird consequences follow if your Lordship starts excluding like this. I'll just give a thumbnail sketch of 3-4 of them. One is, Malaz, no project is carried on with the land being allotted to the main company. I'll tell you a reason for that. The reason is, Malaz, a big company developer has various legacy issues. Your Lordship knows it has some debts, it has liabilities, it has cases, it has fights. So even big companies, all these builders will have that. When they get land allotment, they always create what is known as SPV. New and Nishta are that. So conceptually, Malaz, this will mean that in 90% projects across India, you'll be laying down a new law saying that whenever one of them has the misfortune of going to CRRP, the entire home buyer must be defeated. The second will be, Malaz, the other weird consequence will be, Lordship knows whenever you have IBC, automatically a moratorium springs in. The idea is a single window homing pigeon approach. So once you have IBC, you can't have different suits in the country. You have a single window, the RP. So you have a moratorium. Moratorium is supposed to be all these across the country will go into a single window. Now, Malaz, if you have this interpretation as per the impugned order, what will happen? He is in CIRP. I am New and Nishta. My land can be sold. My land can be mortgaged. My land can be encumbered. With prior permission of GNIDA. I'm saying with their involvement. My land can be reclaimed by them. They have in fact, I believe, cancelled the lease. To cancel the lease.
Restore.
Now restore. So, well, then what happens to the IBC? The project becomes a non-starter. Because the land is separate, there is no moratorium. Somebody, Malaz, I'll give you a better example. Mr. Dhruv Mehta has a claim of 100 rupees. He will sue, saying, I have a mortgage on this land. He can get the land also in a private suit because there's no moratorium. There's no moratorium. Similarly, Malaz, the other consequences, surface may continue. All this stops with IBC. SRPG is going on, that other act is going on, etc. etc. Then RP, who has come in, they're all consequences. Will have nothing to do with the land. So RP is actually king of a kingdom without a kingdom. He's a king without a kingdom. The house building has not started. The RP has got a bankrupt company. He has got no land to stand on.
Yes.
So he is a king without a kingdom. Then I will give the sections that all the functions of the RP itemized by you in section 25, 20, 28, etc. can't be carried out. Except sitting in the office and doing some paperwork, he can do nothing. And ultimately, it will lead to short liquidation. 100% liquidation, which is your lordship's last resort. My lord has said the whole idea of IBC is liquidation is the last resort. It's a nightmare which must be avoided. Then some case law I will give on obvious proposition of interpretation. Please adopt an interpretation which furthers the object of the act rather than retards it. And then I will make a submission about few facts that GNIDA did not file a claim. Under your lordship's COC versus SR, COC SR versus Satish, where I had the privilege of assisting the court, you cannot file claims at this stage. Because you missed the bus. It is going on through all the RP, COC, then section 31 with the NCLT. So therefore you cannot file the claim. But without prejudice, they claim some 19 crores. This is more factual because 40 crores is provided in the plan. But their claim is very strange. A, not filed. B, the evaluator is Mr. Nakul Dewan, who never evaluates. But C, their accounts on the face of it show that 65 lakhs is excess paid to them. Now, I'm not saying your lordship will decide that, but I mean, this can't be accepted, whatever they are claiming, because they never came up to assert their claim. One Neo is 65 lakhs excess, and Nishtha is not excess, but their claim of 1 crore is seen for the first time. I've got the page numbers. In the appeal. Never made legal notice, claim file, nothing. Then the last 2 or 3 heads will be that in any case without prejudice, wholly without all this, the question in the 2 or 3 paragraphs of the NCLT can be solved here and now by having the plan providing for it. Unless you want to pound of flesh saying that the WS land, the wholly owned subsidiary land is mine. Otherwise, the money is there for you. And it is provided for to be paid by Mr. Vishnu Kumar's clients in a pro rata basis. And in pure order, fortunately, gives that way out, but then has a contradiction. And then, as I turn to the list of dates, I will possibly, or my little friend is better equipped for that, Dhruv Mehta, will distinguish 2 of the principal cases relied upon against me. That is Abhilash Lal and BRS Infra. And third one is Embassy. 3 judgments. In one sentence, all 3 on the face of it do not involve a case of a home buyer's project with an underlying land being taken away. So how you can't, that's the fundamental point. They are cases of normal mortgage. They are cases of normal prior rights which will not go under CRP. But the principle they give is very separate. They're very simple. They say that assets which are not part of the CRP CD company will not be part of CRP. That is quite simple and quite straightforward. But they are arising in the context of a home buyer with a WOS subsidy. That's the short difference. So that's what is the lie of the land. Now may I start with the list of dates, which will take a lot through all the relevant documents. Kindly hand over the list of dates. Now the list of dates is useful because it also gives you the clauses and the pages. It's not merely a date-wise account.
Have you improved on the last? I have the same.
It's the same. It is the same. Well, he said there may be some differences. Your lordship is scrap the idea. Lordship will just throw it away and tell the court master to take it away.
In fact, now it seems to have become shorter.
Whereas my learned friend takes responsibility. Which one do you want? The one given now, today? Huh? Well, I kindly take the one today.
Yes.
Whatever it is.
Longer.
Longer.
It's 5
It's
pages.
very rare that we give a shorter versions for this.
Earlier it was 4, now it's become 4.5.
No, but this is actually going to cover the documents itself, and you will then need to go anywhere.
Well,
So the story starts on 4th of February 2008. Please give copies here. I did not give copies. Give an extra copy. Give it quickly. A lease deed was entered into between Greater Noida. This part, Lordship must be missing, not because this side of the bar.
We never filed the claim.
Your Lordship is not this side of the bar, Lordship is missing this. A lease deed was entered into between Greater Noida and Neo, mentioned in the document by its name NIIT Multimedia. Now note, Neo is, I'm just going to read through it because this will cover everything. Lordship will, one second. There are 3 projects. If you leave aside this, my learned friend's Gurgaon thing, there are 2. One is Neo, one is Nishta. They are called by different names, Project Tech X and etc. Neo is a wholly owned subsidiary of Earth Infrastructure. Is a corporate debtor, which was otherwise a shell company with no business of its own, and the entire fund infusion of which was done by EIF. This can be seen from the following documents. I'll be showing some, just read through with me. 458, the information memorandum published by RP shows that Neo is the wholly owned subsidiary. 680, list of shareholders of Neo shows EIL holds 99%. So, when it's a shell company, 99.99 is held, there's nobody else. And no other business, no other asset, no other activity. Audited balance sheet of EIL for 14-15 shows EIL's investment of 32 crores in 1 crore shares of Neo. See pleadings in this regard at 3.69. So this I will say is uncontroverted, unambiguous and undeniable in fact. Undeniable. Important clauses of lease deal. 225, land under lease measuring 58,000 square meters in Greater Noida. This is the Neo land. Premium of 4 crores paid, 4 crores 76 lakhs, out of which 1 crore 43 lakhs was paid and balance 3 lakhs, I think. No, 3 crores, along with interest at 12% payable in 12 installments. Term of lease 90 years. So, my lord, is the basic picture.
what is the plot number? This one? You seem to have some different plot numbers.
Yes, I'll give the plot.
Because in the compliance affidavit, they mentioned 3 separate.
Yes. I'll give a lot. Plot number 1, tech zone.
Plot 1, tech zone.
So, you keep taking. I'll read 1 or 2 dates and I'll come back. I'll read the documents in a minute. Lease deed between Noida as a GNIDA and Nishta. This is the second company.
Yes.
Nishta is another wholly owned subsidiary of Earth, which was otherwise a shell company with no business of its own, and the entire fund infusion done by. So, this important point, I'm sorry to digress. We have to show here that EIL is a wholly owning, completely owning company of these companies. So, it's not that there are other parties involved. It's my alter ego. The CD into which I step in is the alter ego of that wholly owned subsidiary. It has no existence for us beyond the holding. Now, no business of its own, an entire fund by EIL. This is seen by again 458, same thing. Audited balance sheet for 14-15 shows EIL investment. The financial statements of EIL show that EIL has transferred 4 crores from 7 to 11, page 683, and further sums made payment for Sapphire project on behalf of Nishta. So this project is called Sapphire. What's the plot number? Plot 48.
48.
Yes, sector 48. Sector
48.
yeah, sector Knowledge Park, Big Roman 5. There are different sectors.
Well,
That is Nishta.
yes.
Now, important clauses are 248. This is a smaller plot, 20,000. Consideration is 4 crores, so and so. Balance 1.78 crores with interest payable. Then was all the details given, yearly lease, rent, etc. Term is also 90 years.
Right.
Memorandum of Understanding between EIL and NISHTA for setting up a technology park called Sapphire in IT industries and IT enabled services project. Clause 3 and clause 11, the entire responsibility of development of the project from initial till final stage is in EIL. This is important. It's a dummy company holding land only, whereas the lower company. At its own cost and expenses, NISHTA is not responsible or liable to contribute any cost or expenses till development of the project. Clause 6 is sharing of sale proceeds. Clause 10 is terms of lease deed binding on EIL. So, this is interesting. Mr. Noida, GNIDA, gives it to the lower company, the subsidiary. But those leases are naturally binding on the head company which owns the shares because that's constructing. Tomorrow they can't say that we'll ignore Mr. Noida. All amounts received against the project were to be retained by EIL. The following documents are relied upon to show that EIL was exclusively engaged solely in the development of NISHTA land for the project. Now, this again is the third aspect. No other activity, nothing. 284, letter issued by Office of Directors Survey, Geospatial Data Center, addressed to EIL, providing height coordinates for the project site. Letter of Office of Chief Fire Extinguisher with regard to applications seeking NOC for Earth project. Project Earth Sapphire. And then EC issued by SI. Now, your lordships can't have ECs being issued. And this fire officer, if something else is going on, this is only for the known project. They come and see this is the project, this is Sapphire, this is this. It's very specific. And this is given to whom? This is important. To EIL. Thus, you will mark that. To EIL, last line. In that box number 4. So it's not that that subsidiary company is doing it in any manner. Then verse 5. Development agreement between NEO, which is the first party, and EIL for development and construction of residential, commercial, community, facility, apartment services. Now, clause 2A, 298, NEO agreed to transfer development rights along with marketing and transfer of leasehold rights in respect of NEO's land to EIL for development of the project. Power of attorney executed by NEO in favor of EIL. So everything is it's a dummy role, holding land role, for development, obtaining approvals and for booking and receiving payments from allottees. Then this 2D shows that EIL was exclusively responsible for the development work. Sharing ratio of consideration is 10% only because they have the land, and 90% goes to the doing agency, EIL. Then, October 13, your lordship is reached now. The following documents are relied upon to show that EIL was exclusively engaged solely, exclusively word may be underlined and solely may be underlined, in the development of NEO's land for the other project, Earth Tech 1. This is the second other project. Registration certificate by Labour Department. Again, always in EIL's favor. EIL is there. Then this is important. The EC granted by SIA of the state government, that's the delegate of the central government Ministry of Environment, was to EIL for Project Earth on NEO land. The EC was obtained pursuant to para 17 of the building sanction letter issued by my learned friend's client, GNIDA. The relevance of this document is to show that the project was being developed by EIL and this fact was within the knowledge of, suppose there was no letter. It is not possible to argue it's not with knowledge. If his land, he will be checking up every 2 weeks. This is sought to be shown from the building sanction letter which was issued by GNIDA to NEO, which required the permission for development to be obtained by NEO from the relevant authorities. Item 7. The NCLT admitted EIL to CIRP. Now, this is something which is actually for Mr. Noida's benefit. But just pause here. Why did Noida give the land? Forget CIRP. EIL was there. It gave the land to benefit home building. Misfortune fell. The company is held by a shining armor knight like me. I am stepping into the shoes and doing it. How is Noida claiming his pound of flesh? That's why it's a very academic argument. Your lordship is not that Noida gave it for Manu's homes and somebody is building a cinema hall there. Or somebody is doing some amusement park there. Their whole point, why were they? Well, Noida is a land allotting agency inter alia. Their object is to promote industry, promote homes, promote things like that. So that object is being fulfilled. On the contrary, that object was being frustrated by falling into bankruptcy. It's a revival, getting out of bankruptcy. 8. The public announcement Form A under Regulation 6 resolution process was issued inviting claims. So now the CRP has started. RP publishes Form G under Regulation 36A inviting. Pause here, brothers. It is established law. This is in rem completely. You can't come and say you didn't send me a notice personally. No, nobody can come and say. Well, the IT departments, other departments have suffered. This is Noida. It's an in rem notice. 20th of May 19, 8th meeting of the COC shows, page is given, since the creditors of EIL were comprised almost entirely of allottees of real estate projects, they were represented by an authorized representative in terms of Regulation 16A. All are there, brothers. Tech 1 has an amount, a claimant of 1,000 people. Sapphire has 345 people. Very large number. An amount claimed is respectively given 300 crores and 98 crores.
Claimed by whom? What is this amount?
Home buyer. These are all amounts of number of home buyers.
The amount put in by them is this amount.
The only claimants I am told are home buyers. There is no other third claimant.
There's no.
Then was 377 and 388. Since EIL had various projects in different geographical locations, it was proposed that project-wise resolution plans be invited. The aforesaid resolution is seen to have been passed. 381, 382. So now, project-wise, the plans will come. It is not that for you give a mega common plan, you give it for some plan, some project may be in a very advanced stage, some may be in a bad beginning stage. So give a project-wise plan.
Yes.
In fact, because now if I remember, there has been an amendment, just to digress. Now, in the old days, a same company, builders company, I'm not talking about this case, used to have multiple projects. So if the company went into CRP, all would suffer. Now, even before this amendment, before the amendment, the builders got wiser, and rightly so, and they made individual companies for individual projects. So that if something goes down, it doesn't carry the whole weight down. Now here the invitation is for resolution plans from project-wise. And this is a salutary principle. 22/5/19. Accordingly, a revised Form G was published by the RP pursuant to resolution to invite project-wise EOLs. So now we are going project-wise. So they slightly amended or rather reissued. 21/6. Information memorandum, which is mandatory under that regulation, states details of EIL's 5 projects and also that the land under these projects belongs to subsidiaries of EIL. Right from the beginning. And it's a home buyer's claimant. Home buyers are claiming home buyer's project. There's nothing but land involved. What else can be involved in? Including names of landowning companies with respect to these two. We are concerned with your lordship, this appeal only with these two. I'm separate. I am concerned only with these two, not Gurgaon. Development rights in respect of 5 projects mentioned as part of assets of EIL. Details of Earth Sapphire Port are mentioned. Nishtha's land is mentioned as leasehold. It is mentioned that the structure of the blocks is complete. Details of Earth Tech are mentioned. Neo's land is mentioned. Leasehold from Noida is mentioned. It is mentioned that the structure is complete. Everything is given, open. The investments by EIL in its wholly owned subsidiaries, Neo and Nishtha, that is the figures are given 32 crores and whatever, 1 crore, are mentioned. Final list of prospective applicants is published, which says that I am one of the prospective. I become ultimately SRA from PRA. Appellant submits a revised resolution plan along with proposed scheme for allottees for 3 out of 5 projects of EIL, namely Earth Tech 1, Earth Sapphire Port, and Earth Copia. Earth Copia is my learned friend's plan. Gurgaon. That's my learned friend. That's my learned friend. Oh, I see. I'm sorry. My apologies. We are for all these 3. We're not for 2.
You are for
all the 3. I thought that the Gurgaon is the other one also.
Earthcopia is Gurugram.
Gurgaon has to be only excluded because fortunately there is no.
Earthcopia is in Gurugram.
Yes, a freehold land. Freehold land.
That fortunately has to be excluded because they don't have fortunately Mr. GNIDA there and they don't have anybody claiming the land there. There is always freehold land anyway. So that has to be only excluded. I'm sorry, I thought this was another project for my learned friend. While the document refers to 4 projects, it's an undisputed fact that upon due permission being obtained from NCLT, The plan was to be considered only in respect of the above mentioned 3 projects. Now just see this. Summary of claims against Earth Tech 1 and Earth Sapphire. That's all given in that page. Details of claim against Nishta and Neo are provided. So everything has to be, the Lordship knows there's a whole portal where everything has to come so that there is complete transparency. Details of claims are provided. In this regard, where the definition of allottees are stated to include in respect of Nishta and Neo respectively. Now, Malus, just pause here. If this is happening, just for a minute, just take 5 seconds. Are we doing a charade here, Malus? Why are we getting claims invited? Because there is no land, this land doesn't belong to me. This is a whole useless exercise. Am I inviting technically claims the parent holding company, which has got no land? So what is all this charade going on? And nobody is objecting. Least of all GNIDA. Completion of pending construction activities is important and satisfaction of the claims of the allottees by execution of the documents in favor of the allottees in respect of their respective units, subject to making balance payments plus VGF by the allottees. The detailed steps for the plan are as follows. Clause 3, as regards claims against Nishta, it is stated that no further claims beyond those admitted by the RP, a cut-off date is given, would be the liability. This happens in every IBC, otherwise your lordship can't have a cut-off. You will have fellows coming years afterwards. You also should know that phrase just Nariman used is Hydra-headed monster rising from the ashes later on. You can't catch you a surprise and nobody will come. I am supposed to be in any case, I am a stranger, I am an innocent person. I am helping out because I want this property, I am putting in money. Now, why will I come if somebody will jump up later with all this? And in fact, why would I have bid at all if I knew that Noida will take away the only asset which is required for this project? I can get labor, mortar, brick and cement. I need land. Why would anybody bid? In fact, it's a very serious thing. Noida government authority has allowed this whole project of inviting CIRP, inviting a revival to go on and then pulling the rug from under your feet. The carpet completely. Literally the rug because the land is under your feet. Now, 3, your lordship is seeing 4. Plan states that while the appellant has sought waiver of GNIDA dues, in the event, now this is important, in the event that the waiver is not granted, they will be allotted. So they are fully protected without their presence. I would like a waiver, that doesn't matter. It will be otherwise paid by the homebuyers pro rata divided over number of people.
99% voted in favor of this plan.
That is just coming. That is just coming. 99% voted in favor of the plan. 99%. But there are always 13 people like Mr. Rupam Das's client. And there is, of course, Noida, which is equal to all put together. Everybody wants it, but they don't.
Yes.
12.1. The said clause provides for the issuance of a no dues certificate by Noida, GNIDA, in respect of Nishta's land and the conveyance of title in respect of appellant for its nominee. Revival plan for the other one was Earth Tech. That was Sapphire, this is Earth. The revival of the project is provided for by this was identical, I think. So Lordship may skip it. It's identical, mutatis mutandis with the figures. General terms and conditions of the resolution plan. This is again, not for your Lordship's consideration, just note, we will give so much, just detailing. Proposed scheme for allottees. The scheme is proposed by the appellant as being distinct of the resolution plan in order to evolve a mechanism for the day-to-day operation. The scheme provides for management of the company through a board of directors which is under the control of the allottees. It's only important from that point of view.
Hmm.
Now comes one is very important. In November 19, the COC does, of course, your lordships can have even 100%, but your lordship normally doesn't have this kind of unanimity. This kind of unanimity, this itself is sufficient to deal with Mr. Das's supposed dissent. 800 people, he says, and here you have 99.9% of 400, 1400 is all 1400 barring a few people. Of course, anybody can change their mind, I'm not on that. But Lordship ultimately decides things in the public interest, in the interest of the overwhelming number of people. And the threshold has been reduced to, how much is the percentage now? 75%? 66% now.
For which one?
No, now the statute requires only 66% approval. We are far ahead.
So you've not given the details for Earthcopia perhaps. Because at page 3, you've given the number of claimants for Tech 1 and Sapphire Call.
No, it
But
is
not
coming.
for Earthcopia.
It's coming in the next note. I'm on Article 15 is there. Let me read that.
Very.
The note, there is a NOT below that.
Hmm.
The resolution plan was approved for 3 projects. All
Yes.
3. Copia is included.
Hmm.
It is to be noted that Copia is a project in Gurgaon and nothing to do with R1, Noida. Nonetheless, the impugned order resulted in this is a kind of a side wind, and collateral damage. As far as she is concerned, she is collateral damage. She just goes out because the other 2 are going on. So, and the judgment to that extent doesn't really.
There's no minority.
It's got the nature.
Discussion in the
Nature.
review judgment of Earth.
So far as
That's all.
Earthcopia is concerned, all the home buyers are also on the same page?
No, no,
Yes.
no.
We have not decided.
Discussion
We have a
for-
serious objection.
Earthcopia also.
Earthcopia also.
Are they-
And I'll show why.
But the impugned doesn't mention Earthcopia at all.
Very good. But the Earthcopia, how many home buyers are there?
550.
And Manoj, may note that none of the home
We
buyers,
represent all 550 home buyers.
none of the home buyers have filed appeal. Appeal in fact is only by Noida, that's it.
Yes.
550. But Mr. Anupam is saying there's an issue with Earthcopia also.
No, it's one.
You're not
For the,
You're-
I'm objecting.
You're not a home buyer.
Are we all home buyers, Manoj?
He's a
In
already.
Earthcopia.
Yes, yes.
Yes, Manoj,
In
it is
Earthcopia.
not in Earthcopia.
We are asking about Earthcopia.
Manoj, I'll just confirm how many are.
According to Ms. Guruswamy, all 550, she is represented.
Manoj, I'll just recheck in there.
He's the
Yeah.
eternal dissenter. Your Lordship will
Eternal
take it as he is.
appearing for the original promoter.
So it's very convenient for the purposes of CIR.
Representing at least, by way of an illusion, any home buyers.
Yes, 18 buyers in Earthcopia.
18 buyers.
And we've given a list also.
Very good.
So whenever they want to come to this,
Just have, you don't need to argue right now. You just need some clarity on whether Earthcopia, everyone's on the same page, according
Yes.
to 18 of them are not with the remaining 550.
Which is the association of home buyers I represent.
You're also appearing for some.
So far as Earth Town is concerned.
No, we're asking about Earthcopia.
Exactly.
There's
There's another Earth town
That's a
also.
different project.
That's a different.
Different SRA.
No,
He's finished his.
we'll come to that later.
Note contains every.
Yeah. So what is
This
that?
doesn't refer to Earth town.
No. I'm.
You're only
grappling with.
these
In fact, only 2
These
out of
three.
3. Because
These
Gurgaon. Just note a very interesting. There's a book I forget what called the Eternal Dissenter. This person does not file an appeal. He's today objecting to all plans. Then file an appeal.
In champion, PCLT.
So you are not challenged. Today, number 1. Number 2, of course, he'll have a ground. Dissenter will always have a ground. He has no free, he has a ground on a freehold land. There is no Noida there, as far as Gurgaon is concerned. The main ground which he has is not there at all, existing there. Anyway, let him alone. Now just read that note first. The resolution plan was approved for 3 projects. Tech 1, Sapphire Court and Copia. It is to be noted that Copia is a project in Gurgaon, Haryana, nothing to do. Malafred is said not mentioned in the impugned order.
Yes.
Nonetheless, the impugned order resulted in the setting aside the entire plan, which I said is collateral damage, as far as they are concerned. Now, Mother, this is very, very, very important. On 6th of June, the plan is approved. All of them, all the plans. 658, the reliefs claimed under the plan are granted. Now, Malas, we're just ending this now, 17, they wake up. This judgment is coming on May 2021.
Yes.
Your Lordship have them waking up Malas from slumber in 2021, November. Malas, actually, Rip Van Winkle slept for 21 years. Our local hero, Kumbhakaran, slept only for 6 months. Malas. This is 2.5 years. Home credit set for only 6 months.
Yes.
Now, 11/11, GNIDA filed its claim in respect of Neo with the RP. And with the serious consequences, what is so special about Noida to disrupt and sabotage the whole thing with such serious all India consequences? Along with the Form C as a FC under Regulation 12, claiming 19 odd crores and calling upon RP not to take any action for further transfer of leasehold rights under application. The claim was time barred, having been filed with the after the approval. That's a lordship SR judgment directly. Even as per a payment intimation letter of 3/6 issued by Noida to Neo, an amount of 65 lakhs in excess to be paid. The claim now raised by G Noida is untenable this account also. G Noida filed the appeal bearing so and so. This is important point, but it is right. This claim which your lordship finds in item 70 is only for Neo, not for Nishta, even at this belated stage. It's important. He's now descending for everything, but there is no claim belatedly for Nishta. This one at item 70 is only for Neo. That's correct. Then 18, Noida files the appeal. They say 19 crores is payable from Neo and Nishta is liable to pay 11 crores. This is obviously an improvement. It's a significant improvement of at least 11 crores odd. Then this appeal in the Supreme, there is more. They file a cross appeal also and higher claims. This claim amount differs from so and so. Then in tune order, it succeeds that you come for the first time in CLT, and then they also cancelled in June 23 the entire allotment. In fact, it would render the entire project unviable. We say that there is no point going to contempt and all. We said this is a breach of a status quo order, etc., etc. They restored it. Now, kindly come to my
Status quo order passed by this court.
Yes. Now, some documents on this, but we are not showing the documents. Just to, actually, this is good enough because this is incontrovertible. I am not going to put mine, but just a few documents just to check up and to see the flavor of the documents. Just the minimum. Come to the first item, in item number 1. Go with sequence. 458. But I think these are not required in the information memorandum, the first 3 documents. You also have got it there. I mean, what I am saying can't be controverted. You can see. Come to the lease deed, 225. 1 minute, go to 225. Open it here. Just for some clauses. At 235. Yes. At the bottom of 224, as one says, the parties. Bottom of 224, whereas the lessor is desirous to facilitate development of IT, and then only it's not relevant. Now, when figures are starting at 225, they are all basic clauses. I'm sorry, my lord is gone. Yes, Aradhe is gone. So the rest is all the essential figures are given. Come straight to 235. Yeah. Don't go back.
235.
Yes. QRST, 4 clauses. I'm going to ask your lordships.
Yeah.
My lord is keeping that list of dates open on the left side. So it will help my lords. Yes. And the first 3 documents, I'm not reading the list of dates, which are the information memorandum. Right. That's a given. I'm reading only the lease deed. The lessee shall have the right to sell, transfer the developed plot of land and or the built up space as per the limitations of P above at its own price. The lessee shall have to sell, transfer the permissible residential developed plot and or built up space to the owners of the IT industries and IT enabled services. No transfer charges shall be levied by the lessor for the first for this first sale of developed plot and or built up space. The lessee shall provide the list of its bona fide users from time to time in whose favor the sale has been executed. However, for subsequent sales, the lessee shall take permission from the lessor, which will not be unreasonably withheld. If such sale also conforms to the provision. So, transfer is contemplated, the power is there. Transfer charges as prevalent at the time of transfer will be payable. Apart from that, the lessee shall have to take the approval of the lessor on the draft lease deed to be executed between the lessee and the sublessee. S is not very relevant, just read it. T is the real relevant one. That the lessee, sublessee shall use the demised premises for the purpose for which has been allotted and no other purpose without the consent of the lessor and subject to such terms and conditions as lessor may impose and will not be to suffer done on the device premises, any part, anything, act or done, which may be a nuisance, damage, etc., etc. That the lessee will in no case, except as mentioned above, assign, relinquish, except in favor of the lessor, the project and facilities without prior permission. The transfer of plot lessee's legal heir will be allowed with prior permission. Now just pause here. I am saying something in GNIDA's favor. In the normal course, your lordship will deal with it as it was drafted. Nobody contemplated in the drafting a CIRP where I step into the shoes. That's the 1 point answer. The minutiae my lord has seen, RST. So the interpretation of my lords must be that for this limited exception, these clauses can't be interpreted literally. I'm saying something in their favor. In the normal lordship law, all land giving authorities have these clauses. If I give you the land, you can't sublet, you can't assign, you can't do a cheating that well, you formally don't change it, but internally you sublet it. But that was never contemplating in IBC 58F. Apart from the part that all the word transfer, I've read the word transfer 3 times. There's no transfer involved. None.
Yes.
Then now, Malas, the alternative argument I'm making is that if there is a transfer involved notionally, because ultimately what will happen is when the things are built, your lordship will have to convey a title. So pari passu, I will convey a title. So I don't think that I'm saying that he has no case at all. If he does a very hyper literal interpretation, well, the lordship has land, your lordship has a building, the lordship has these people buying, these people get a sale deed ultimately in a pari passu or a proportionate thing. So there is that sense of interest transfer. But that can't be interpreted like that. Lordship in that case must interpret it the way I am submitting this. Otherwise, the lordship may repeal 58F by judicial interpretation. The whole problem is a very literal interpretation and applying this provision to something never contemplated. And the funny part of this lease deed is that you gave it for development of homes. Now, V is also on transfer. Just to go, V is 237. 237. That again transfer word comes in. Every transfer, assignment, relinquishment, mortgage, subletting. So all are covered, no doubt. Of any but part or whole of the projected facility shall be subject to the terms of the lease deed, and the transferee assignee shall be bound by all covenants. So clearly, some of this will happen when the home buyers buy it. Transfer means whether I'm not giving it out for some other purpose or giving it out illegally. This is not for the project. It's for promotion of what you gave the land for. Then the proviso is given on the same page, 237. Provided always that the lessee or her transferee or permitted assignees, as the case may be, will assign, relinquish, mortgage, sublet or transfer the device, premises and building as a whole or residue on the said terms, he, she will deliver at his, her, etc. own expense to the lessor at its office attested by the assignment, relinquishment, mortgage or transfer deed together with a notice within a month after the same shall have been duly registered under the Indian Registration Act or any other amending section. Now, first finish this document. This document is over. No, go to the sequence. Let's not jump. Now, lease deed is done. Now, item 2 need not be done is identical. We will also disturb it because it's a parallel to the other company. Parallel. Now, come to item 3. Please follow this. Now, this is the agreement, MOU. This is Mala's agreement between the EIL and the subsidiary, the 99% subsidiary. And it makes a reverse binding. Just see 3 clauses here. Come to Mala's 279. 1 second. It starts. I'm not seeing orange. You will tell me. So 270, please tell me.
279.
Yes. This is the MOU between the CD and its subsidiaries. And everything is under the control of Noida. It is not that we are having an agreement kind of taking it out of Noida. This subject of MOU is for utilizing the same for development and setting up a technology park named as Sapphire Court. The developer shall pay so much. That the developer shall develop the said plot at its own cost initiative and expenses from the initial stage till the complete final stage, which shall include the obtaining of sanction of plans, availing the maximum FAR, construction of permissible areas, fitting fixtures, lifts, power, etc., etc. The owner, wherever necessary, would sign up the application affidavits. The owner is one of who? The landowning company. There also be in a private party that would say, you have to give me a power of attorney.
This arrangement is for tax purposes.
No, but it's also practical. Technically, when I go for a permission to a waterman, he will say, you are not the owner. Who the hell are you? The owner is new and NIDA.
Why do they have this holding company and a subsidiary? The lease is in favor. Why do they create NIDA in the first place?
Yes, that's very important. That's the heart of this matter. All over India, not in this case, not unique. 1 minute, sir. All over India, the landowning company is supposed to be a clean company without a baggage and a legacy. So the land giver, GNIDA, is the one who insists on it. And rightly so. Suppose the land is given to Manus the CD. Today, what would happen with this? The whole Manus, suppose Manus he has some other history and he gives a mortgage of the land. Suppose he has got some other litigation.
Some
So the
other
idea is
financial creditors can act against this land.
No, not only that. The thing is that you have the company itself will have a balance sheet with a legacy. They want a clean slate. So, but it is very clear to everyone that it will be used only for the project. So that's why WIS is there, and the very fact is 99% without doing any other action. And this clause makes it clear that you will give me permission, that is well as the WOS, the wholly owned subsidiary, will give permission to the owner, the principal company to do all these permissions. Then the developer shall finalize the plans and the specification in consultation with the owner. The developer shall obtain the sanction of the plans, etc. This I can skip, fellows. Come to 6. That the sale proceeds of project built up area would be shared between the parties. Now, fellows, he is the owner, so he gets 10 or 15%, as the case may be. Then 8 fellows is the developer has agreed to utilize the said plot as per the terms of the lease deed in compliance. So, Mr. Noida should not be worried. As per the lease deed, in compliance with the present bylaws, as applicable and in force and in conformity with Noida. Now, technically, I can say as the CD, which is now the SRA, that I am not bound with Noida. Technically. Obviously, I can't. Para 8 makes it clear. I am binding myself with prejudice. None of their obligations are being intended to. It's not about the Lordship has some circuitous cases. It's not that kind of a case. I am binding myself to something I have not technically signed, but it's my wholly owned subsidiary for land, etc. So I understand I have to be bound. Then 9, the developer will book forget 9, come to 10. So 8 and 10 are important because 8 my lord is read. Guidelines are 10. The developer shall abide by all the terms of lease deed and also of laws, rules, regulations in respect to said property or imposed upon the owner, shall not commit any breach in any manner. If developer breaches any of the terms of lease deed and the owner suffers any kind of loss, then the developer shall be fully responsible. Hereafter be liable or responsible, shall not hereafter be liable or responsible to pay or contribute towards any cost or expense till the completion of the development. The developer shall be solely responsible for every loss, injury, etc. The owner shall, however, be liable for the payment of demand of greater Noida. That's between them, the lessor and the lessee, if any revised. Then, 283, the last page, para 14, clause 14. It is agreed between the parties that till completion of the project, whatever amount is received against booking and further installments shall be kept by the developer, and the owner has the right to get detail of the same. Obviously, the whole thing is being done by the developer. That does item number 3. 4, I think we can skip, Malas. My lord has got the itemization. Just note 4, Malas. 4 shows that everything is being done by developer. Fire authority, environment authority, this, that, director survey, etc.
5 is identical agreement.
5 is the counterpart agreement to 3. So should we skip that? I hope I am clear. 5 and 3 are the same.
6 is the counterpart.
Now, 6 is the same thing for 4. There are two dates for everything. That can be skipped also. 6 is the counterpart to 4. Now let's come to
this letter which Greater Noida is supposed to have given NEO,
Yes.
which you mentioned in the 6th
Yes.
Is that relevant? Does it indicate anything at all?
Yes, I think you're also right. Let me show it. Please come to 332. Come to 328 first. First come to 328, yes.
328.
So this is only for knowledge, fully. This is for knowledge. My Lord is right, I should have said it myself. This is October 13, just before Lordship reads it, just 2 points.
Yes.
In October 13, they say that, look, what are you getting permissions and how are you going about it? What is it for? Do they think I'm going to build it in the air or on their land only? CIRPS starts later, but that time they asked me, the landowner, that is the Neo, just come to 328, is addressed to Neo Multimedia.
This is in March 2013.
This is March 25, correct?
March 23rd.
Conditional with respect point number 17 vis-a-vis notification and its amendment issued by Ministry of Environment and Forestry. So this is the building sanction letter. I have to inform you that sanction is granted by GNIDA with the following conditions. Now, 1 minute. Conditions are, so many are detailed given. Come to 17. Before starting construction, the NOC is required from Ministry of Environment and Forest and amendment from time to time under notification of 14.9, whichever is applicable. The copy shall be submitted to the authority, which means GNIDA. If construction is started before obtaining the NOC, the sanction shall be treated as cancelled. Now, this they are saying to whom? Neo must get and give to them. They are telling Neo, you please give it to me, you are Neo. Now at 332, next page, the state level, which is actually a delegate of the central level, gives the environmental clearance. Don't jump the sequence. Rajneesh Mittal, director, this is to the CD. This is to the CD. Environment clearance, so full knowledge is there, everybody knows about everything. Please refer to your application dated so and so. I don't think there is anything, all the minutiae is given, detail is given there. To the edge. General conditions come at 337. It's a very long, detailed set of conditions. Don't skip anything. Next. Then, item 10 I think will suffice. 9 is formal. 9 is that statutory formality. Come to 10.
Yes.
In 10, if your Lordship doesn't mind, turning to 370. Minutes of the proceeding of the 8th meeting of so-and-so, held on 20th May 19, so-and-so attended. There were COCs there in full force also. Your Lordship turns the pages. The details of claim comes at 374, I believe. All the attendees are there. Now look at these details of claim. Copia is also there, but Lordship underline 3 and 4 for my purposes.
Yes.
374, this is, my Lords have got. In the 3rd and the 4th is Sapphire and Tecon. So, the claims are around 98 lakhs and 98 crores and 3 crores. 300? 300 crores, sorry.
300.
300. And if your Lordship then goes to 376. Form G formalities, my Lord, is covered. They start discussing there. They say there are only 4 inquiries have come through prospective applicants. Skip that, come to 377.
Yes.
The RP received request from the COC members that one plan may not be feasible for the company as a whole due to peculiar circumstances of the case where 5 different projects are in different stages and located in very sensible ones. And then they give for me, Tecon and Sapphire, and the exact addresses are given. Then come to 378. The chairman informed the COC that members have requested the RP to invite plans project-wise. Also, as an alternative, in addition to the resolution plan for the whole company. Accordingly, RP has put the agenda item of voting or approval of eligibility criteria for project specific, in addition to the plan for the company as a whole. What about this? What about this? Now, Lordship basically underlined 98 crores and 300 crores also. The number of claimants are given also, Malus. By the way, Lordship has seen the number also. They're all home buyers. If your Lordship comes to Malus, page 374, they're all home buyers. 374 and 1000. 1004. Now, Malus, your Lordship comes to item 11 is the fresh one issued because they say we have to now do it project wise. Don't go to it, not necessary. Now come to the information memorandum in 12, which is 412. So they change and issue Malus the comprehensive one.
Have to go to volume 2. Volume
Yes,
2. Is it there in this?
It's probably volume 2 minutes. You're ready to exclude. You don't have to argue. Four one two is the continuous page, maybe in volume 2.
Yes.
The page is here.
Yes.
EIL is a real estate developing company and its primary business is development of residential and commercial complex. I'm reading the second paragraph.
Yes.
At present, EIL has developed selling rights of 5 projects. Development selling rights. The land of these projects belongs to the different landowning companies, etc., etc. Then Malus Sapphire Court and Earthtech 1. And then every detail is given. Then your Lordship will come to 426. Besides the above, the corporate debtor has development and selling rights. I'm asking the underlying of development and selling rights everywhere. Developing and selling rights of 5 projects. The land of these projects belongs to different. As a matter of fact, the whole exercise is a charade because there is no land. The whole thing is going on. There is no IBC possible. This is a classic example. If your Lordship allows this judgment to operate literally, there will be no 5 project where the company owning the land is different. And every land agency insists that it should be different. A very strange thing. Besides, and who will come? Well, suppose your Lordship put a clause here that you please bid subject to prior permission of Noida to allow your bid to succeed. Well, I'm giving your Lordship a stark case. Suppose this had a clause saying you cannot bid unless you get prior permission of Noida. We are not bothered. We can't handle it. Well, this has had many failed attempts. Who will come? How will IBC succeed? How will the home buyers who are 1,000 get anything? Besides the above, the corporate debtor has development and selling rights of 5 projects. Land belongs to different companies, which are subsidiary companies, etc. In other words, I'm grateful to my learned friend. Development rights, and your Lordship was clearly noted the word development and selling rights. It is clear that you are coming not for any company which claims falsely. My learned friend could have argued that I have the land owning rights also. It is not saying that land is owned by EIL. It is obvious that land is owned by its subsidiary. It is development rights. Earth Sapphire Court is at page 428. Landowner is given clearly. Why do you have all this charade if you don't have a land? Why is the name of the landowner given at 428?
Yeah.
Then come to 8. Yes, you're right. 8 is very interesting, leasehold. I hope I'm clear.
Yes, leasehold. Property freehold or leasehold?
This one I'm showing is leasehold, clearly. Nishta is shown clearly. Lesser is Greater Noida. Lease date is so-and-so, period is 90 years. In contrast, my learned friend for Gurgaon has 426. Turn to 426. This is my learned friend's
Freehold.
case. 8 freehold. So, why is all this going on then? This is completely futile exercise. Then come to 429. Present condition of buildings. Structure work is completed. Brick work is done, etc., etc. Then comes the same thing on 430 for the other companies. Skip it. 431. Skip it. Same thing for the 2 companies.
Yeah.
Then come to 458. What is hidden? I mean, I can understand if you can say that, look, you hid something from these prospective knights in shining armor. What did you hide? What did you misrepresent? What was suppressio, whereas ratio falsi? This 415 is another aspect. All financials are disclosed.
Yes.
Investment in subsidiary companies. First company is Neo and number 9 is Nishka. 100% is the ownership. Investment is 32 crores. In the second one, it is 106 or 1 crore. 100%. That's 100% also.
Yes.
This covers brothers, that item. Now, brothers, item 13 publishes the list. Come to my plan, which is very important, at item 14. And the relevant pages will be starting from, I believe, 465. Come to 465. Just start with 465, then I'll go to the other page.
Yes.
So 463, if you want, forget that. 465 it starts. 481? Wait.
Yeah. Yeah. Somebody claims. You
know that. You know that, please. 481.
Yes.
Now, what is evaluated by Mr. Diwan's client, what is looked at, what is filed, what is claimed, all that is summarized at 481. So, admitted claims for each project are given there. I don't want to trouble you with the figures. It's 155 crores in the admitted item in Sapphire. In Tech 1, it is 439 crores, which is at pages 481, 482. This is a very important exercise, because it is not that you open the door for IBC and anybody walks in. The evaluation of claim, anybody can file a claim. The evaluation is very important. This is the admitted. Then, 489 need not be troubling. Effective date is given. Come to 490. Please see 9 also. This is one of the points where is against us. I don't want to skip it. 19, page 489.
489?
Yes. Effective date. This is one of the points against us. I'm just saying it has to be read in the context. Transfer doesn't mean that you can't transfer anything. Third line, effective date.
Yes.
Further, in accordance with the approved resolution plan, the relevant government authority shall duly transfer the land in the name of the resolution applicant and or the relevant project SPV. Mark this. That's the answer. I am not interested when it says the proponent. I don't want the land for anything else myself. I have to fulfill the project. Nobody will buy them. Who will buy a flat there? As provided in the resolution plan and provided all certificates including NOC and requested waivers and renewal of all applicable licenses and other approvals received for construction, etc. Now the word transfer was used in a general sense, but it doesn't mean you have this kind of CRP defeated. Then come to page 490.
Yes.
Noida dues, GNIDA dues. Now it's important. This is provided in the plan. It's taken care of in the plan. You have not woken up from your slumber. You are sleeping. You have not filed a claim. But nobody is trying to cheat anybody. Had you been there and said, no, it's not 10 rupees, 11 rupees. Or 9 rupees. But the point is that we have still provided for it. GNIDA dues means payment towards lease rental, additional compensation, financials, principal, interest, penalties, dues, including any demands or claims for registration charges, which are pending against Earth Sapphire or Earth Tech 1, or any other claim which have been called and or which shall be due for payment. This is a statutory exercise intended to be comprehensive, not to exclude anybody, even though that anybody is sleeping. Then come to Malad.
In this document.
534. This actually dot.
This will show
the other things are commercial wisdom issues about. Yeah, I don't want to write anything. If it wants to read something, I'll read it, but I don't think it's necessary. Come straight to Novelist 534 in the same document. There are a lot of clauses which deal with one of the nitty-gritty of the commercial wisdom issues.
Yes.
Again, Malus in 534 with great detail, Noida comes in. Rather,
What is this document?
same plan.
Same plan.
Same plan. Well, Noida. This Malus nomenclature is common for them, but it's actually Greater Noida. It's come this first line. The title is wrong. As per the IM, the claims admitted do not include dues payable to
Where
Greater
are you
Noida.
reading?
Well, I'm sorry, para 4, page 534. As per the information memorandum, the claims admitted to, it's a very fair disclosure, do not include dues payable to Greater Noida. The resolution applicant proposes not to take any liability pertaining to G Noida that may arise for transfer of the land in the manner as proposed. As such, admission of any claim will make the project unviable. Further, the resolution applicant seeks waiver of G Noida dues. So this part is clear. Every applicant will try his luck. However, look at the fairness of it. If such waiver is not granted by G Noida, then such dues shall be proportionately distributed amongst the allottees of earth. Well, nobody will make a project successful if the home buyers who approved it, Noida is not approving it. Home buyers have agreed, but a small number of 13, etc. are saying, what can be fairer? It's between me and the home buyer. The home buyers have approved this plan. Then, Malas, nothing in between. Don't go back. Malas, all these clauses, the next 3-4 pages are minutiae and details. Come to 11 now, which is at 543.
Dr. Singhvi, you've taken 1.5 hours yourself. Hopefully the others don't have to add too much to it.
That's
And
true.
your side,
Let me
you have to wait and see.
hive off 2 things to my learned friend and I'll try to end quickly. I just want to summarize my thoughts. And what is right. Goes to everything. 11.1 is 543. The resolution applicant proposes the Earth Sapphire Port be transferred to the project SPV in such a manner that all necessary assets, rights, approval, consent, direction.
Where are you reading? Which one?
I'm reading 543. Supervision and implementation 11.1. Resolution applicant proposes the Earth Sapphire project be transferred to the project SPV in such manner that all necessary assets, rights, approvals, consent, licenses be provided to the project SPV. Be provided to the project SPV to enable it to revive and construct the Earth Sapphire with the intention to safeguard all its stakeholders and most importantly deliver the units and register. It's a facilitative provision. Do the job. Please don't obstruct me. You're doing the opposite. 11.2 balance. In light of the fact that Nishta's name has been struck off by the relevant jurisdiction registrar due to statutory non restoration of Nishtha will be necessitated to effectuate. So that was another problem with the ROC notes. Then last 3 lines of that page of that para, best interest of Nishtha and its stakeholders and most importantly public interest would aid in the allottees eventually receiving. Next para is very important, unnumbered para. The resolution applicant proposes to demerge the Earth Sapphire Port project along with the landowning company, namely Nishtha. It further proposes to merge Earth Sapphire Port along with Nishtha and the relevant project SPV, that is known as Rosebuds, which shall be subsidiary associate company of resolution applicant. Then, Maras, as per them, they rely upon Maras, item 12.1 at 545. Yes. They say this is completely wrong, illegal, we can't allow it, we'll object to it, proposing it, and is a major offending clause according to them. Greater Noida shall issue the no dues certificate with respect to such land in favor of the resolution applicant and shall convey the title in favor of resolution or SPV as desired. Any work of construction has been executed by the previous management in the project. I'll just pause here. What is so offending about it? Your Lordship knows single window, hydra-headed monster, your Lordship does 0 for income tax crores. In every IBC plan, your Lordship has done 0 for so many large crores. Point 1. Just on this clause, this is one of the main arguments. 1. 2. You have not taking recourse to the option given by the impure order itself of paying 40 or working out 40. 3. You are ignoring that 35 or 40 will be paid in the plan, per the plan by the home buyers. 4, you have specifically taken the stand that no, I want the land owning jurisdictional ground to be decided.
Right.
And 5, the object of IBC is to make it single window and extinguish all other claims. Here you are not extinguishing. Well, I'm sorry, 5 is important. You are getting 39 or 40 crores without being a participant till the NCLT. You never participated if you are so vigilant about your dues, but now you are saying no dues. Dues be damned. I want the land. Anything else? Then this is the plan. Now this I think the Lordship will come. The other project is 580. Forget that. Come to 15. Identical to the other project. 15, it is voted upon. Show me quickly it is to be shown. Yes, no time. Not to be shown? Yes or no? This one. Not
Number 99%.
just see one part of their approval at 615. Just see yes or no. Don't discuss it. Don't try it.
615.
Relevant at 615. Starts earlier, 608. Incidentally, the law also is interesting. Even if only 66% is approved, it binds the balance 33%. That's a very direct judgment. Here 99 have approved, just see the middle of that page. Authorized reps. So my learned friend is stopped. He can't. Let's assume he's dissenting. I'm not saying he can't dissent. He's bound. Because the law is a class action. It's not an individual action. It's a class of persons. Then, the impugned order, see those few paras, and then I'll come to Malas. First see the NCLT and then see the NCLT, and then I'll come straight to my submission. I don't know. NCLT approves it, starting at page 620. Wait a minute.
Yes.
By now, these same people. We don't know the individual, but home buyers objecting as individuals had also come in here. So they are IAs by them. In this approval order, they are already IAs. All were rejected. Now, this starts at 61620.
You didn't get 99% in favor. You got 91.39%.
Yeah.
Is that right? 615. So there were 8.61 who were against.
8%. Correct.
So
Right.
those individuals came before the NCLT.
Some of them and rejected. But my point was that 8% will be bound as a class. Fully bound as a class. Because a lot of, in fact, in the old days, the normal merger and demerger and the 391s used to have these voting. So voting will always have a large class saying no, but it will still be no class always is bound. Now let us come to the last relevant para of the NCLT. It goes into great detail on the plan. Now I don't want to show it to save time because it says the plan is good, the plan is beneficial, the plan is necessary, etc. etc. In para 27, it says resolution applicant is prayed for the relief. I'm sorry, page 658. 658. Take out the relevant paragraph and see. Take it down last. Only the relevant. The resolution applicant has prayed for the reliefs as enumerated under the resolution plan from the plan approval date. All inquiries, investigation to write on paper, whether civil, criminal, etc. interest in connection with the CD or the affairs pending or settled, present or future, in relation to any period prior to the plan or arising on account of implementation, shall stand withdrawn. This is the meaning of this is your Lordship format order. It's passed by every NCLT across the country in every IBC. And it's a format order. Otherwise, no plan can succeed. Because that's the Hydra-headed person popping up after 3 weeks. So look at the language. From the date of approval, the resolution applicant shall be legally authorized to seek appropriate order from respective authorities for renewal of license, withdrawal, dismissal, abatement, etc. Then I will skip this for us. It is signed at 661. Come to the impugned order straight away.
Let's start.
The impugned order, it will be Malas. Is notice with them? No. I also give the one page, only this part. Only this much. Anyway, Malas, just see, the relevant issues for consideration are at page 56. Keep this page. Just Page 56 it starts.
You don't have to read out everything.
No, no, no.
Just tell us the relevant pages so that we can.
I'm giving that. Give it now. I think this is easier one. Give it to me also. So Manu, just see, this will be much faster. So your lordship will straight jump the first page, Manu, which has got contentions, contentions. Every
Discussion.
item is given.
Discussion.
And the issues are important, Manu. It comes to page 56 at the bottom of the second page. Whether assets, subsidiary can be treated as assets, whether resolution plan could have provided for transfer, whether assets without prior permission, whether assets can be dealt with, the same issue which I have argued broadly with us. Then page 3 talks, whether GNIDA was required to be made a party to the CIRP and heard before approval, whether RP acted within the ambit of RPC, whether GNIDA. So the real issues are, Manas, the first and the second issues really, the natural justice issue. Now discussion. Page 61, your lordship, I'll just read some parts. Let's come to 61 itself with the body, keeping this paper open. Keeping this paper open.
Yes.
61.
Yeah.
It comes. Go in sequence. The assets of the man is about 5, 10, 7, 8 lines from the bottom. From the bottom. Thus, assets of the CD and assets of the subsidiary of the CD have been separately recognized and dealt with. Section 18 explanation. This is the legal basis. Further clarified that law when it says that assets shall include the assets, meaning thereby assets of the CD shall not include assets of any Indian subsidiary. This is without, when before the home buyers concept came in. Didn't come in. In the CIRP debtor, the assets of the subsidiary company, Earth Tower, were not to be taken into consideration as treated as the assets of the CD. As regards the law relating to resolution process of a corporate person is concerned, the law is concerned with the assets of the CD and its liabilities so as to focus the resolution of assets of the CD. The natural corollary to the above is that the assets of the subsidiary cannot be dealt with, etc. Next relevant page is. Don't say all orally, the page. Well, if the clause is noted at 53, 54, just see that without reading it. Don't discuss it.
We see them.
Which matter? Not here.
Yeah.
Well, there is a slight factual thing. That clause which said waiver, if no waiver, they will pay. This clause is not in all cases. It's there in my 2 cases. I believe that without wanting to deal with the case, it's not in some cases like Mr. Meenakshi Arora's case. So there's clauses. Now, there is some confusion by the learned judge because of that mix-up. At page 53, what is quoted, the right clause is reproduced in 53. My clause.
Dues to us.
So the last 5 lines my lord has got, however, is such waiver.
This is your
Yes. However, later on, the learned judge Willis in that judgment hold I am not paying the dues at all. Where is it? Because that other clause was there in the other one. Now see that. Let's go see.
Very well. So your resolution plan is a little different from the others.
Because of this clause. I have to pay, and in fact, now it is distributed. I have to honor
that distinction is not kept in mind.
Just go on and on. Now let us come to 62, where embassy is the judgment relied upon. The judgments I will request.
You've already said that.
Mr. Dhruv will
Not
see judgments.
Very.
Then come to 64, para 46. The Honorable Supreme Court clearly noted that assets owned by a third party which is in possession of the corporate debtor under contractual arrangement specifically kept out of the terms. Now all these 3 cases, Avilash Kumar, this fellow was BR and this embassy were cases not dealing with this situation at all. That's the simple distinction. Then let's come to page. Page.
Yeah.
At 68, the IM is looked at. Para 50. The information memorandum is discussed and see the last 3 lines of 68.
Yes.
Or just see, not last 3 lines, see the 10th line from the bottom. When we look into the information memorandum as a whole, it is clear that land was a leased land, leased by the appellant to landholding company, However, IM does not indicate project land belong to CD in any manner. Thus, the IM also in no manner represented that the CD is the owner of the project land. When the information did not include the project land as the asset, there was no occasion to include. It's the other way around. I spoke the truth. I said, Nishta has got this land, this is their project. It's used against me. But this is actually directly using something which was candid. But had I said something else, it would be a misstatement, Your Lordships. Then 69, fourth line, this finding, the resolution plan seeks to transfer not only the development rights but also the title of the land with certainty without obtaining the approval. Transfer of land by the lessor was subject to clauses of the lease deed and permission to transfer. The resolution contains the provision of apparent obliged. So this is the finding was obviously against. You have to go to the law. Now let us just see those two contradictions. One is that therefore the plan is cancelled. Give me that balance straight away. And then what is the remedy also there? 74 or 73 or something. Okay. Just give me a minute. Sorry. See it here. Well, is it 77 to 84 is also one of the single economic entity discussed, which is the corporate whale issues. That there is a single concentration of economic entity where we have the law also. In page 92, at page 92 from para 67, the transfer of land thus is statutorily governed and terms of
The order we will go through, Dr.
Yeah,
Singhvi,
just the
will
contradiction.
point out to us. You already noted that the
Yeah.
contradiction you pointed out.
Yes, so that was 67, 68, 69
Right.
are those paras. I'll not read it then.
89.
And
Not
89,
necessarily. You want
89.
to take us through the order.
Very good. Last
Not
thing,
necessary.
last thing, page 109 is that clear remedy which Noida reverse.
They
80,
are in appeal against that observation.
yes,
obviously.
108, page 88, 108, page para 88.
Yes.
We have to find out ways and means to protect the interests of allottees, paramount importance. The developer has failed to carry out the project. We have also noted the written submissions, etc. This is the one. 89 onward.
This aspect will keep.
Now, the directions we want to be set aside are from 89, 90, and 91. So, direction 1 is 89. 89. It is obvious that appellant before granting any permission shall require the dues pertaining. So this is the way out provided in the plan. Then 90 in the middle. We are of the view that appellant has not been diligent to take steps toward recovery of dues, not entitled to any penal interest. We direct the appellant to waive the penal interest, recalculate the dues of the appellant, which was due. Then Malas, then we dispose of the appeals in para 95. Order is set aside. Appellant is directed to recalculate his dues payable by the respective landholding company without charging any penal interest. The appellant is made party to the CRP of the corporate and shall be entitled to participate. There is a Noida one. It's all appellant in Noida. After receiving the details, the resolution provision will publish a fresh form. This luckily we stayed for us, otherwise this would have been over by now. Fresh form. Your Lordship state this. The appellant shall consider granting permission for the transfer of project land of 3 projects. The resolution plan so received shall again be examined, etc. In any case, it is contrary to destroying a hearing completion and restarting it. The delay part also is against the Lordship public interest in all cases. Now come to my submission very quickly. Point number 1. Point number 1, I'll be very quick. I'll just summarize my submission. First submission is those same clauses.
No, the clauses.
This note? This note again? Yes. Yes, kindly take this note. Now, many of this will not be required because I have read it. Yes. I only make the submission. Turn to the first one. Yeah, I have not read it. Yes. The resolution plan in respect of Sapphire Court did not provide for transfer. As per the plan, the appellant is stepping into the shoes. That's number 1. All the clauses are done. This is the basic point. It's a misconception completely. Your Lordship will put 2. Don't follow this numbering. Against para 3, put number 2. That's my sequence.
Yeah.
7 is cited on the vanilla provision, which he has for all clauses. Don't transfer without my permission. That is section 7. Wrong. Then third, if your lordship doesn't mind, come to page 7. That's why I'm saying that is because Paras big Roman C, big C. That's my third submission. That's the most important legal submission. I'm going to take 5 minutes on that. This is the most important legal submission. The interpretation placed on 18, I not saw that finally.
You don't have to read it,
No,
Doctor.
I will do. I'm just going to. The explanation is there.
Well, I don't understand. You already put it in writing.
At least a copy should be shared. Reading class. Every time we have to ask them.
But whatever documents you place before us, please share it with the other side.
Every time we have to
My
ask them.
apologies.
Wait for it.
Yes.
Now, this is the section, next page. Therefore, the amount raised from an allotee, the boldface, referred to in the explanation to 58F, cannot be limited in its meaning to the amount raised in respect to a real estate project exclusively by the company. This is the proposition. My lord, I can read the section, but it's very.
Not necessarily.
You should got the section. Then, the deeming section, case law 1997, 1 SCG, please take it as read, but very important. Take to its logical conclusion. I'm asking myself, what is the, even not logical, even the intermediate conclusion of Parliament is to get it done.
Yes.
Now, pioneer is very important in para, below that so-called para 2 there, on that page. The use of the word shall be deemed to be an explanation inserted with a real estate, held to be clarificatory in nature in pioneer, in para 18.
Right.
This further supports that all other provision of IBC must be read so as to always be intended to cover a situation with a real estate developer. Now, I know it's not so, but the idea was that it will be a smooth sailing.
Yes.
Then, the object, very important, I'm saving time, note para 16, where the insolvency committee report is reproduced by Justice Manu. That gives the object. You are thwarting and obstructing and defeating the object completely. Then paras 18, 42 and 47 observe that the construction of the housing project was also, I happen to argue with those who say don't include home buyers in that case. Justice Manu upheld on these grounds. He upheld on these grounds. The object is this. Now, it's just weird consequences. Just these are the consequences.
But you've already put it in that.
Right.
You don't have to read it.
So, but these go on to the next page.
Yes.
All of these. And the next page, I think it will take 5 minutes. An interpretation which furthers is the bottom of page 9. 3 cases are given. Right, Manus?
Yes.
And now, if your lordship will come, lastly, to page 7 of this note. On bottom of 6 is views of GNIDA. This is factual, but I made the point of not arguing it. This is factual that there is an excess. That is my para at page 7, 1 and 2.
7?
Yes. No.
It's only 5 pages.
No. So it's
Which one are you referring to? Not because this one, these two. Business
without
change.
prejudice. It's just the case.
You've got a different set of. You've got only 5.
Point 3 on page, your lordship's page will be
You what you read out
Page
here is there, para 16 is there.
page 2
After that, we don't-
without prejudice. That page is 2.
Page 2.
That's the factual.
Oh, without prejudice.
Yes.
That's
Two
para 3.
merits of the claim. I'm sorry,
No.
this for some additional
Yeah,
excitement.
if this is what you are arguing, then we'll go through this. No,
Yes.
no difficulty. That's
So
all then.
there are 3 cases which I'll request parents to take 5 minutes.
Well-
on. The basic point to remember, this is not to do at all with the home buyer situation. And
That way, you've already said it. Please do not repeat it in the. Yes. So,
Look, I'll not
Dhruv
repeat
Mehta, you're appearing for whom?
Say, alpha.
For Alpha.
Yeah. Lord, I won't repeat because I've been here for Lord. I've had the benefit of my Lord, my friend's submission.
As brief as possible.
Certainly,
We've already
certainly.
finished.
Certainly, my Lord. 2-3 things I want to point out, my Lord. Just have a look at the IBC. How voting takes place, my Lord, in case of, my Lord, allottees or whom.